from those basics, there will be two divergent approaches depending on who you are representing. For the applicants, clearly you will be wanting to suggest to the reader and to the court that there are grounds for review, and that when you examine how the law relates to the issues or facts, that this is a case where the court should be exercising its discretion to intervene and review the decision-making process. You will be asking for a remedy, and you'll be asking for a remedy in context that we know that the court has a discretion to substitute some other more appropriate remedy that the court may choose to give if it's in the mindset of giving the remedy. And in terms of remedies, the thing that we'll look at next week in the lecture is the court's process that it goes through in terms of deciding on remedies. And in a nutshell, what we'll be looking at on Monday is a two-step thought process that the court will go through in relation to remedies. And remedies, as much as the law relating to grounds for review or what principles of administrative law might be in play, is part of the applicable law. So as an applicant, you want to deal with grounds for review, deal with something in relation to remedies. Primarily, whatever it is, you've arrived at in terms of your conclusion, and that the court should exercise its discretion to grant a remedy, and that in your view, the most appropriate remedy will be whatever it is. From the respondent's perspective, sometimes facts are very slanted in a particular way. And when you're responding to something, you're actually mounting a defense. The key to how you would deal with defense lies in the route that you give to the defendant, sometimes as the respondent. You respond to real issues. So it's not about looking at a set of facts and thinking we have to respond to absolutely everything. When you go through and you identify issues, you identify the key things that you must deal with in order to succeed. And from the defendant's perspective, the relevant law will be the same. You'll be dealing with grounds for review, and you'll be dealing with remedies. You'll be dealing with them from a perspective of not contending as to why they apply and why the court should be exercising its discretion to review and grant a remedy. You'll be contending the opposite. basis of the facts, the credible submission to make is that there might be grounds for review.
So can you admit that?
There might be.
Right.
But when you apply the relevant law, you come to the conclusion that the court should exercise its discretion. Prime example of that is the Auckland casino case about bias, case about perception of bias, case about community interest. What was until then irrevocable presumption in New Zealand law of disqualification. The court said no. We have balanced that. There's a balancing that goes into how we apply laws. The court has a discretion, even though it might come to a view that somebody has got something wrong, that it's not going to intervene. And there are cases where the court may not intervene in all of the grounds for review. You see the quote from Joseph, you see the quote from the other representatives. Remedies are also important because even where the court comes to the conclusion, contrary to your powerful submissions, it should review, goes ahead and does that, there is the issue of remedies. And out of the remedies, there will quite clearly be some that will be unpalatable for your client, some that will be more palatable. Clearly, your client would prefer not to have any remedy granted against it. But in terms of things, again, it's a balancing exercise. Remedies to that process. The court has to go through that logically. And there's enough in there to argue why it should be one remedy rather than a softer one rather than a harder.
So we should, even though we're arguing that maybe there is cause for review, but probably shouldn't.
You might not.
We might not, but then we still also present it. So I guess if the court decides not to take the way, we can present the best remedy that we think.
You can go. It's not. If you look at the Justice Wilson case, the heart of Wilson's case was what he had done was not that serious. It was not serious enough to warrant the appointment of the Judicial Conduct Commission. So in terms of your answering what's been said, you're not answering everything. The other thing about the fact that you are going to exchange your bits of paper after you finish writing, and there's going to be no right of reply, don't try and second guess things. Even though you know who you're up against and you know what people's thought processes are, and you think that these guys are likely to go for a certain avenue of defence, don't try and second guess them, just write it. Because there's always a 50-50 thing on second guessing that you're wrong. And that you've got a case which is pick the wrong assumption, and if you've done that, you're not going to come out good. Certainly in the moot part of the exercise.
In this particular moot, like the last week of the moots, the appellants and the respondents pretty much had mirror images of their issues. I was saying it was for, one was for against. But you're saying here like we're going to have most likely separate, completely different issues.
No, you've got the same issue, you've got the same fact sheet. So you've got problems, they're all facts, and it's relevant law in it. Dealing with it. But it is a different way around these things. It's also different, it's also slightly different because of within principles.
And so we're exchanging after this anyway.
Yeah. You get to see each other's things. You can use headings and subheadings in your work. If you think that's relevant, or if you want to be economical and not use headings or subheadings, you can have a paragraph which explains the order in which you're going to deal with things. And usually having a roadmap paragraph might only be a long sentence up front. Quite a medium piece is useful. Because immediately the person who's reading your work, when you come to present your work, already have got an understanding in terms of how your argument fits together.
So it's still appropriate to number our paragraphs. So if we're standing up in the moot, we can say paragraph 3 point such and such. That's still appropriate to do, or
We'll just deal with the oral side in a minute.
sure.
In terms of the academic side, because this is assignment work, a component of the marking for the academic side goes in terms of the research we've done. We've got the basics in terms of the yellow book. We've got some basics from the lecture slides. You can get additional information from Joseph's book. But in terms of, say, if you're aspiring for an A+ mark, the thing that makes a difference is that you go beyond Joseph's book and you look at one of the other books on the list. And you're able also in your answer either to point to another New Zealand case or some other New Zealand cases, or maybe an overseas case that's relevant in dealing with the same point. And if you take an issue like bias, for example, whilst there are some differences of legal viewpoint and approach, broadly there is a lot of similarity and commonality in terms of this area of law. The only thing that you need to be aware of if you're looking at one of the Australian texts is that their grounds for review are codified in the statute. They're no longer and they have 15 grounds for review.
But UK is not, then similar to us.
UK is more similar.
Can do it to be careful.
UK is more similar to New Zealand and Australia. simply because of how they compartmentalise the grants for it. Dealing with the oral side, rather than reformat your work as a legal submission for the court, because you're going to be in pairs, what will be really good to have is from each pair a single sheet of A4, simply with headings and subheadings on it, in terms of the order in which you intend to present an argument to the court. And in relation to the headings and subheadings, a pinpoint reference to the relevant paragraphs and page references in terms of the written work that you've got. So the court will get your assigned work, and on the day when you do your presentation, because you're not going to be reading it out, you're going to be presenting, and you might want to present your stuff on the day in a different order than you've written it. define the thing, the information you're getting at, the legal argument, you can take people through. And rather than have a single sheet of paper per person, I'd invite you to have a single sheet of paper per team. Because it's just an index. And in terms of the day, what we'll need to do is to nominate a person who will speak first and a person who will speak second. There's no difference in stature between the first and second speaker. We've had some people for some years who have annoyed the moot court intensely by referring to the second speaker as the junior. Not appropriate, it's more ranking in terms of our ability. And in terms of the presentation, you will have 20 minutes, you have 10 minutes each, but combined, what will be being looked at is that you've covered the bases. So it doesn't matter which side you're acting for, whether you're on the respondent side or the applicant side, you put together a presentation, an oral presentation on the day, which hangs together seamlessly. In terms of the 2 blocks of 10 minutes and the 20 minutes total speaking time, it's not an awful lot of time. So it will be a matter of thinking carefully about what you present. Normally, 10 minutes speaking time is the equivalent to about 3 pages of A4 material. So combined in terms of your assignment work, you'll have more than you can present, so you won't take the call through every piece of detail.
What if you go over 10 minutes time? Does that mean it reduces your partner's time to talk, or would they keep going until you finish your submission?
No, you get cut off. Which is a principle that they don't apply in the court in New Zealand, but they do apply in the court in Queensland. You're asked to give a time period for your submissions. That's your time period.
Do you want
Also, because
an overall conclusion after the second speaker, or do you want the first to conclude their stuff and bring in seamlessly into the next one and then
Well,
interview?
logically, you can have an introduction.
Yep.
You have a lot of stuff in the middle, and you have a conclusion. So, what there will be, usually in terms of the 2 speakers, is there will be a break. So one person will get to set the stall out and deal with part of the substantive delivery, and the other person will get an opportunity to deal with other aspects of the substantive delivery and to give a conclusion. In terms of the introduction should be capable of being condensed in terms of thinking about how you will present it on the day into no more than 3 sentences. Ideally, you should be able to deal with it in 1 sentence. If you are future QC material. So anywhere between 1 to 3 sentences in terms of introduction. In terms of conclusion, you wouldn't expect much more. Because hopefully the way in which you structured the middle part, the substantive delivery, it will be clear because you'll be following logical progression and it will be questions can come from anywhere. There's no particular thing that drives how folk judging stuff, whether they're real life judges or pretend judges, take questions. The only way that you can, and it's no use trying to second guess it, the only surefire way of dealing with it is in your one-page summary, headings and subheadings and pinpoint references to where what you're going to be talking to underneath those things, is knowing your stuff absolutely inside out and understanding things, and in relation to working as a team, actually having an understanding before you stand up and speak who's got a better understanding of the case so and so. And there's nothing wrong if you get the bold question about case so and so, and you know that your colleague has got it absolutely taped and you haven't. You can ask the question. Because what you're wanting to do is to perform as a team.
Does your colleague stand up right then and answer the question, or do you say that they'll answer that question in there somewhere?
No, you simply hand it over. You hand it over there and let them answer it there. Because if you don't, if you keep folk waiting for the answer, then they might have forgotten the question when they get the answer. Why am I getting that? Or they might get grumpy and ask lots more questions.
So like when that problem does occur, like you just say, oh, I've passed this question on to my partner.
Yeah.
Your partner, you sit down and then your partner stands up and presents it, and then after.
Yeah, and after they finish, they sit down. The other thing with questions, answer them succinctly because they're going to take away from your presentation time. So out of your 10 minutes each, 20 minutes globally, you should factor in possibly that there might be 5 minutes of diversion. Total. No, total, about 20 minutes. So that your 10 minutes might in practice only be 7 or 8 minutes.
So if we've tweaked a bit in and we're not asking many questions and we leave 10 or 20 minutes to go, is that bad? Or do you have to pull it up with something?
Just conclude, or if it's clear in terms of the first speaker not getting asked any questions because the moot court judge is still reading the problem and processing information. Then if there is something more that you can add in terms of a point because you're getting towards the end, then yes, you've got the luxury. You've got the luxury of dealing with something in slightly more detail because you're watching the clock. There will be time keepers, so there's a sense of that, but don't get carried away. Oh, brilliant! We've got 2 minutes. We've got 2 minutes, and it turns out that what you're going to put on something in terms of space is about 10 minutes. In terms of the material, the one-page summary and material, and how you present matters, the presentation in terms of what you refer to doesn't necessarily have to come from your own piece of work because you're dealing with this as a team. And although you're going to speak to a certain substantive issue, the pinpoint references might be in your own work and Adovcacy, and in your partner's work. And particularly, for example, if you dealt with a line of New Zealand authority and your partner's got a brilliant English or Australian case, you clearly want, in terms of giving a seamless presentation of that part of the substantive that was presented, to draw the court's attention to that brilliant case at the same time.
So again, if the judge brings up questions to do with let's say again your partner has a brilliant line of English cases. If questions are brought up, you just refer that to your partner because they'd be more aware or more familiar with those cases. Or yeah.
So it really is being aware in terms of who's on top of what issue.
After your partner's answered the questions, do they sit back down and you continue with your speech, or is it now there?
No, they sit down.
They just answer the question. Refer to the case study.
Obvious point, you will know far more about your cases than the court will. So in practice there's nothing to be frightened about in terms of an oral presentation. Equally, it doesn't matter what, I'll put it differently. I've met some people in life who will swear blind that they are never nervous in court. It's the biggest load of it's like acting on performing or doing anything else. There's always an element of nerves there. It's natural. Just factor it in. On the day, you might be nervous. It doesn't matter. Will anybody else notice? Most likely not. Why? Because everybody in the room will be nervous. Yeah, because they're just playing a different role. It's like anxiety and stuff is there. It's normal. Just ignore it. That's intention. But at the end of the day, you are the experts in terms of your cases and your presentations, and you need to approach it from that mindset. If you are confident that you've actually done the best piece of work that you could do, then there's something wrong. Because, and it doesn't matter what grade you get. I know it does in one sense, but the grade is irrelevant. We're satisfied that we've done the best piece of work that we could do at that point in time. We've done the best piece of work that we could do at that point in time. And it's in that respect that you're experts. You'll have done the thought process, you'll have polished some writing, you've done some research, looked at your work. It will be coming to you fresh. They'll have the proper question. They'll have the copies of the relevant cases out of the yellow book. We'll give them the titles of the texts that we've suggested that you might go away and read. They won't go to the library. They might not even be familiar with the titles. And you'll have your people that have your pieces of written book. On the day you'll rock up with your single sheets and then this is what we're going to achieve.
Trevor Wright from Tauranga, and this is a fundamental question. I may have missed it. And it's basically, what time of day are the moods going to be?
In the evening.
Starting
We normally start at 6.
Right.
And depending on how many judges we have, we normally take about an hour and 30 minutes max.
And what days do you like prayer at night?
It's in the book. It's Wednesday.
Well, where are we doing it?
Here.
Yeah, are we doing it in a...
Most likely one of these flat rooms. And after the stuff's been done, it takes a while to get months and later than that. But there's usually about half an hour of hanging out and having
Your marks a day.
we look for security for widows and that, yeah.
With regard to the, you said we have one single paper for the, are we allowed to bring our other submission in case we forget?
Oh, you'll have your piece of written work, your partner's written piece of written work.
Just trying to work off the.
I would suggest that you both have a copy of each.
Yeah.
That you know where you're going in there, that you have things in your, when you're going to be taking somebody to a paragraph and either reading a sentence or reading a paragraph or summarising it, that you've got key things highlighted in there. That you put sticky tabs on the side of things so you can find things. Use all the relevant things that somebody would use.
I've got a dispute resolution date in here that like that.
It's basically just hit contents list and menus. So the person sitting in front can see clearly exactly what order you're going to be dealing with things. And in terms of heading and subheadings, one of your subheadings, if there's a particularly important case that you want to report to, might be the name of the case.
So do we get that bit of paper to the judges as well, so they know where we're going?
The judge will have your problem question, and they'll have your two pieces of written work. They'll have that already.
But they don't have our index.
They won't have your index. And they'll know that when you appear on the day, that they should anticipate getting a single piece of paper from each
So we give them one.
Outlining how they're going to be arguing the case. Speak clearly. If you refer to things, make sure that the person can actually turn to the page. That they're not looking confused because they're holding the wrong piece of paper. And that they actually look engaged with it. So there's a lot of watching and making sure that people are following things. Any other questions? Just follow the style guide. And that's why we put the working style guide up on. Finding crack getting the lectures on the home page too. Nice and folders there with them all in there. And you also got slides for all the lectures right through until last week, which we're holding back with the meetings.
Did you say a mooting style guide?
The judge's marking guide, is that right? The judge's marking guide?
Yeah. Gives you an indication of what people are looking for.
So just one advice to make
Just in case you're looking for it, can't find like the actual scenario.
I can't remember anything being there last night. Probably was.
Obvious thing in relation to this exercise is looking at the course outline in terms of the special consideration procedure. If either you or your partner has anything that would qualify for special consideration,
Hmm?
How marks are dealt with. In terms of the various periods, so far I know that in one period there was a person who is not doing too well, and that might have a bearing in terms of things. So the advice of that person is fill the special consideration forms. Have a look at the special consideration plans. If you qualify for it, fill the form in and advance. And in terms of the moot court, clearly there are privacy issues around disclosing to someone who's going to sit and listen to what's happening. Provided there are no privacy issues around that, you might actually need to indicate out of wanting there is special consideration there. And we would want to factor that into the market. People deal with that on a very careful basis.
The fact that we're in two different cities, does that give us makes it more difficult to collude?
No.
Alright.
I think why, because I live in paradise, that's the problem.
Anyway, paradise can be a
I work with some folks in Ottawa, the fact that we're in different cities doesn't give us special consideration.
Did you do a moot with them?
No.
Can we
But I have to meet with them.
get a response on
In Ottawa? No, on postcard.
extra like our cases? Because what we've learned, I feel like what we've learned this year is really in favour of the people that are applying for judicial review. So, like, can we find, like, in the other textbook, what's true? In the other textbooks, will we find cases, etc., like other than the Auckland casino case? You know, like, will we find cases for that we can use in those books?
Well, you can use cases by analogy. I mean, the one good thing about the Joseph book, if you follow most of the text, it's footnotes, it's stuff full of references to case authority. As a general principle, the court has a discretion about embarking on review. And if you can't find if you're dealing with natural justice, if you can't find a natural justice case about exercising discretion not to embark on review, you might look at some other judicial review case where the court's talked about that discretion and extracts a principle. Because that's what judicial review cases are all about. It's about the principle that you can pull out of the cases rather than necessarily this was a case about review of the Ministry of Immigration, or this was a case about review of ACC. In fact, it's not terribly interested in the subject matter of the case. It's the principles that you can pull out of it. So yes, the respondents will be looking at the question of discretion to review and discretion as to remedies. People will be looking quite widely about that. And administrative law argues a lot by analogies. So yes, it's not a case that's directly on point, but it's a case about the court in a review situation dealing with discretion. Yeah. And there's nothing wrong in saying that this is the case that this was the case that dealt with different grounds for review, but by analogy these principles come out of their role. What I don't have, what I can't put up on Moodle is one of the presentations from last year. It was resolve this issue for next week, we might actually ask you all to give a release. It's photocopyright.
What's my guarantee?
Well, I don't think we're going to be sort of ticket earner for royalties.
I don't know if we're making verses, I think, but this is what you should do, that's what you should do.
If we were going to put something up, you always put it up as an example of something that's good.
Okay, thank you.
But if you've got something that's particularly bad, somebody shouldn't fall into the same pitfalls, then yeah, we listen to you.
That's everybody all be drawn in. So you put a bad one up, everyone's drawn to it.
Yeah.
They keep repeating the mistake.
That's when there's no examples next year.
A completely separate issue. Each year we have go through the process of appointing the tutors for the paper. And sometimes we have lots of people who apply, and some years we don't have many people who apply generally to be tutors. I've always had an individual view, which is that we should offer prizes for papers, which are tutorships, because tutorships have some money that's attached to them. If you have a general view, concurs with that, if you could let me know by email at some point between now and the end of May. Because if there's a general view that people who do well in this paper could actually be in a position, because it's all very fresh, or some tutoring next year. Because otherwise we get a PhD student who might be 6 years away from this class, or a master's student who's 4 years away, or a fourth year law student, depending on whether they're conjoint or how they've done their papers, is at least 2 years away from. And there's no disrespect to people, it's just that the fresher you are to something, and particularly if you've done well, then those two combinations ought to stay. Choose the next one. Everybody unhappy? Everybody happy?
Yeah.
Everybody got no decided view? Anybody prefer Winston figures for next Prime Minister?
Would be an interesting one.
Choice, Winnie or Johnny there.
Don't give me head to the left. Think what you would be in the running for that. We're off.
Alrighty.